All right, welcome back to the Law and Crime Network, Law and Crime Report. My name is Bob Bianchi. I would actually call this the trial of the century and even maybe the century before. It has really come to a head right now where civil rights and police misconduct is confronting the criminal justice system. It has sparked the nation. There is lots of controversy on both sides. And we are talking about the trial of former police officer Derek Chauvin with respect to the murder charges filed against him for George Floyd. I don't believe there's anyone on the earth that hasn't heard about that case, and we're going to talk a little bit about what that means down the road. But there was a substantial court ruling with regard to a third-degree little charge that was in the original charges that the trial judge threw out, and the defense was very happy that it was thrown out. Prosecutors appealed it to the appellate courts, and the appellate court said, no, based on another case that we've recently interpreted that has not yet been reviewed by the state Supreme Court, we believe the trial judge was in error and asked the trial judge to go back and have another hearing with respect to findings as to whether or not that third-degree charge is going to be admitted to the jury or not. And the importance of this we're going to get into because there is a critical strategic reason why defense lawyers don't want that third-degree charge there. As a result of some of these developments, jury selection has been somewhat delayed, at least until tomorrow. And again, remember the trial was supposed to start on March 29th. Jury selection expected to take some time in order to find fair and impartial jurors. Let's listen, though, to some of the argument that was being made with regard to this third-degree charge, which has become the epicenter of a battle between the prosecution and the defense.
Do you agree that as far as entertaining the motion to reinstate murder in the third degree, that I do not have jurisdiction to even entertain argument about that at this time? Would you agree with that?
I would agree, Your Honor, that the court does not have jurisdiction to issue an order until we hear from the Supreme Court. However, I would disagree that the court can't even entertain argument on it.
Okay. Let's assume that I decide otherwise, that I don't have jurisdiction even to consider argument because jurisdiction is currently at the Court of Appeals on this issue. What's your view as to the extent to which jurisdiction has been transferred to the Court of Appeals? And are we, as Mr. Frank has said, limited to, we essentially have to shut everything down right now and wait?
No, Your Honor, I actually think that the rules of criminal procedure are very clear on the point. Rule of Criminal Procedure 28.04, subdivision 2, paren 8, the last paragraph specifically says, this is the provision dealing with pretrial appeals by the state. The last paragraph specifically states that an appeal under this rule does not deprive the district court of jurisdiction over pending matters not included in the appeal. Because the only issue pending in the appeal is the reinstatement of the murder in the third degree charge, that means that everything else is within the court's jurisdiction. There are two additional charges, murder in the second degree as well as the manslaughter charge, jury selection, motions in limine. All of these things can be accomplished. I just wanted to inform the court that we're prepared to try this case. It is not our intent to cause delay by filing a PFR with the Minnesota Supreme Court. However, I feel I have an ethical obligation to my client and to other criminal defendants to do so because it was a published precedential opinion. We're prepared. The petition for review is actually prepared, subject to some minor edits that we need to do. So I intend to file this petition post haste, Your Honor.
Okay, so this is a lot of wonky procedural issues, but they're very, very important in the long run. The question here being whether or not the defense is going to actually file an appeal to the Supreme Court to say, before this trial starts, we need to know what it is we're defending. Are we defending a third-degree charge or not? And that is the reason, because I have a number of cases that have been analyzed in the state of Minnesota where they were saying that the actions that have to be directed towards the prosecution saying can be directed towards a specific person, and the defense is saying, no, the way that this law reads is that it has to, and just bear with me for a moment as I turn the page, it has to be eminently dangerous to other individuals. It has to be more than just one individual. That's the legal issue at play here. So what the defense lawyer is saying right now is we should still be able to go forward with our motions in limine. Those are things about what evidence will be admitted or not admitted. We should still be able to go forward with jury selection because it's going to be a slow and arduous process as they try to make an appeal to the Supreme Court. So our very own Brian Buckmire has some information with regard to the selection jury questionnaire. And let's take a listen to that and come back on the other end.
Jury selection is one of the most important phases in the Derek Chauvin trial. And a 14-page questionnaire sent out to some Hennepin County residents is providing insight into what both sides are looking for in jurors. Potential jury members are expected to complete a questionnaire with nearly 70 prompts in 6 sections. Among the questions, list all details you know about the victim and defendants. Have you watched the video of George Floyd's death, and if so, how many times? Did you participate in demonstrations against police brutality? Did you or someone you know get injured or suffer property damage during the protests? Part 2 of the questions focus on media habits, including what is your primary source of news? How often do you see news updates on social media? Part 3 is about police contacts. Have you ever personally seen the police use more force than was needed? Have you ever been restrained or put in a chokehold by law enforcement? Then, the potential juror is asked to rate their opinions in a lengthy list about how they feel towards the media, discrimination, and trusting police. The questions continue, and jurors are asked to explain how favorable or unfavorable they are about Black Lives Matter and Blue Lives Matter. Finally, they're asked to list their age, gender, education level, work status, and marital status. The questionnaire is only one part of the jury selection process, but the court is hoping it will help streamline the trial. I'm Brian Buckmire for the Law and Crime Network.
Awesome, Brian. Okay, we have with us Lara Yeretsian, criminal defense attorney out of Glendale, California, Los Angeles Police Commission Police Permit Review Panel, former chair, top attorney award in Pasadena Magazine, and also awarded the Southern California Super Lawyer and Super Lawyer Rising Star. Lara, tell me about what you think the overall dynamic here is with regard to this battle that is going on about this third-degree charge. My theory has always been the second-degree charge is going to be harder to prove for prosecutors, and they want that third-degree charge a little bit of a fallback because they're worried if the jury can't really come to a conclusion on the second degree, it may drop down to a much lower offense. What's your opinion?
I completely agree with you. I mean, look at what happened in the Noor case. Another officer in the same area is convicted of the third-degree murder. So they're thinking if the jury decides, you know what, it's difficult for them to show the felony assault because this is an officer and whatever he's doing is the defense can argue this was part of the policy. He's allowed to do this. Maybe they won't see the felony assault for the second-degree murder, but they might find a compromise charge, which is going to be the third-degree murder. It's going to be a little easier for them to prove with the causing imminent danger to others. In this case, it would be, if the court agrees, of course, the appellate court has said that it would be George Floyd. That you could easily see possibly a jury reaching to that, depending, of course, on the evidence and how the defense moves forward. So yes, it makes sense. No wonder. Go ahead.
Yeah, I was going to say, do you find it a little interesting that the defense is appealing this? And just to educate our audience, usually the courts, especially the Supreme Court, is very reluctant to get into the middle of an issue like this until a complete trial record. And they usually will grant appeals if the prosecution seeks it because there's double jeopardy consequences, as opposed to a defense lawyer where they say, work out the case, and if anything was done improperly, it can be reversed and retried again. What do you think the likelihood the Supreme Court hears this?
Well, this is a case that the entire nation is watching very closely. You never know. I guess it's 50-50. We'll see what happens, but I mean, if I was in a defense position, obviously I would want the Supreme Court to take this case because then maybe there's a chance that the Supreme Court says the appellate court is wrong. Otherwise, you know what? Unless they've got some other arguments here, this third-degree murder is going to come in.
Right. Now, let's go a little bit back to that second-degree murder charge for just 1 second. And while there's no intent with regard to wanting the death of the individual, it's the underlying offense that's at issue, which is to create an assault or bodily injury, the felony of doing that. And there you have to prove that that was the intention of Derek Chauvin. And listen, everybody can look at this tape. It's horrible by any stretch of the imagination. I don't think there's a person out there that disagrees with that. But what about that legal nuance that you have to show that's his intent? And people often say, Lara, well, police cases, they get away with a lot. And that may be true, but that's because police officers are allowed to use levels of force that are different than me and you.
Correct. In this case, basically, the prosecution would have to show that he committed felony assault. If this was just a regular person on the street, of course you're putting your neck on someone's neck, you've got the felony assault. But for an officer, it's a little different. I mean, officers, they've got guidelines, they've got policies that they follow, and there's certain procedures that are allowed for officers. And we'll find out, I guess, during this trial. The argument by the defense has been previously, at least, that this was something that was permitted by the policies. So he was within his rights to do this. This is part of his job, and he cannot be penalized for it. So, in other words, this cannot be a felony assault. This is something that he's doing. Maybe there was some excessive force, but it doesn't necessarily mean that he wasn't allowed to do this, and this was felony assault. That's why it's going to be a little more difficult for the prosecution to prove the second-degree murder, and that's why they're fighting tooth and nail to get the third-degree murder in. And especially that my guess is that they don't want the manslaughter either. They prefer getting a murder charge, a murder conviction here.
Yeah, exactly. The point being that if the jury can't really come to that second-degree murder charge, it may wind up dropping it all the way down to a manslaughter, which would be a max 10-year sentence as opposed to a max 40. But now let's explain to the audience why that third-degree murder is so important to the prosecution. It doesn't require intent. It requires that the act is eminently dangerous to others. And that was the part of this argument. What does to others mean? And that it evidences a depraved mind without the regard of human life. So there you don't need to show any intent with regard to an underlying felony at all. You just have to basically say evidencing a depraved mind with regard to human life. And that is what I think you're getting at. The prosecution's got an ace card there because nobody can look at that tape and say, after all that time that went on, that it didn't evidence a depraved indifference to the life of this person, and no intent is required in any of that.
Exactly. Imagine the entire nation, if not the world, has heard George Floyd's words, "I can't breathe," and you see for over 8 minutes, almost 9 minutes, Derek Chauvin's knee on his neck while this man is having trouble breathing and voicing that concern. I mean, it's etched in everyone's mind. So was this behavior that was eminently dangerous to him, and is there a depraved heart here? That's an argument that the prosecution could potentially easily make, and an argument that it can probably sell to a jury. And that's why, as we've said before, the defense does not want this to come in.
Right, exactly. And we have those comments that were made calling out for his mother, and then there was no comments and he was limp. And of course, all those people that were watching it were seeing what was going on. And I think the prosecution is going to use the show to say even the citizens understood that was a depraved indifference to the life of George Floyd. Excellent point. And why that third-degree murder charge is a crucial battleground right now. Going to take a quick break. We'll be right back. All right, well, welcome back to this amazing trial. And, we have some developments going on right now with regard to that debate over that third-degree murder charge, which is going to be a very important issue in this case. And we have jury selection's been delayed a little bit, but then we can't have to end that there because the Law and Network team has boots on the ground, and a lot of them. Angenette Levy is out there. Angenette, I know that you has put some materials together for us. Let's take a quick listen.
Concern for people to really see what's going on here. People want a good outcome, and we know that everybody, whatever happens, not everybody's going to be satisfied, but what we want is to be able to be unified in the end, and we want people to feel peace and security and love in the end, and have our cities still be our cities.
Yeah, and that was actually a pastor that we spoke with yesterday at a march. There was a silent march for George Floyd. There was also another event involving mainly clergy in the Minneapolis area coming together and praying for peace, praying for the outcome that they want to see happen in this trial. Now, things have been delayed a little bit this morning, obviously, as you mentioned, because of the issue with the third-degree murder charge on Friday. The Minnesota Appeals Court ruled that Judge Cahill needed to take another look at reinstating that charge against Derek Chauvin. So that has been sent back to him, remanded. He's been told to kind of look at that, but the Minnesota Attorney General's office doesn't want anything proceeding with this case until that issue is decided. And Derek Chauvin is going to be going to the Minnesota Supreme Court and asking for a ruling on this, asking for an appeal to review this issue on his behalf. So Derek Chauvin doesn't want to face that third-degree murder charge because that gives the prosecution yet another option for a conviction. Obviously, the prosecution wants that third-degree charge because they can see that as a way to get another conviction on a murder count rather than a manslaughter. So things have been delayed here. They were going to take up some motions. The jurors who had reported here, the prospective jurors, have been sent home for the day. So right now, everyone's kind of in a holding pattern. We had protests going on down the street this morning. We still have some Black Lives Matter protesters hanging out on the street here, just listening to music. They've been painting signs, laying flowers on the ground, things like that. So a lot of tension here, a lot of uncertainty at this point. So we're all kind of in a holding pattern, just waiting and watching to see how everything unfolds. Bob?
Yeah, Angenette, are you getting the impression, or do you see out there that there are counter-protesters, those who were in support of Chauvin in this case, or do you expect that they will appear?
Yeah, we haven't seen that yet. We kept an eye out for that yesterday. We've also kept an eye out for that today. We have not seen people who support Derek Chauvin coming out en masse to show that support. I can tell you, though, however, I have seen comments online from people who do support him, who don't believe that he is guilty of the murder charges. They actually believe that that George Floyd died of a fentanyl overdose coupled with some heart issues rather than the actual restraint move that was being used by Derek Chauvin and the other officers.
Yeah, well, Angenette, you know, when you come to police cases, the difficulty isn't so much that juries won't convict it. The difference is that police officers are allowed to use so much more different levels of force than the ordinary citizen. And the question is really going to come down to whether that was reasonable, in my mind, for a police officer based on their training and experience. We will see. Obviously, a horrible case is horrible. It does not look good. And I think that's going to have a huge emotional impact, as we can see is already developing out there in the community. Angenette Levy, you are the best. We will be back to you later. Thank you so much.
Thanks, Bob.
You got it. Okay, so Brian Buckmire is out there, as we said before, with a number of our crew, as you can see, and he's also going to break down the witness list. Now, we have to always provide a witness list before trial so that both sides have an understanding in the court as to who may be called or not called as witnesses. So we always scour those witness lists because it gives you a little bit of a blueprint on what the case may be. Let's listen to Brian talk about that.
The trial of Derek Chauvin is anticipated to be one of the most high profile in the nation's history, and court filings are giving us a preview of what to expect. Lists of potential witnesses to be called at Chauvin's trial are now public. The prosecution's list has more than 300 names, including the 3 other officers charged in Floyd's murder. They're slated to go to trial separately this summer. Also named is George Floyd's brother, felony Floyd.
Everybody watched him scream for his mom. He pleaded for help, and nobody cared. They kept their knee on his neck for 8 minutes and 46 seconds.
The defense is naming more than 200 of their own witnesses, including local police officers, state agents, and experts from law enforcement and medicine. Use of force expert Barry Brode testified for the defense during the trial of ex-Chicago police officer Jason Van Dyke in the fatal shooting of a black teen in 2014.
I feel that Officer Van Dyke's shooting of Laquan McDonald was justified.
Chauvin's defense also listed the Hennepin County prosecutors removed from the case by a judge. The case is now being tried by the Minnesota Attorney General Keith Ellison's office.
A long process toward justice.
Many names appear on both lists, including the woman who recorded the incident on her cell phone. Both sides also named Minneapolis Police Chief Madaria Arredondo, Fire Chief Brian Tyner, and Hennepin County Medical Examiner Dr. Andrew Baker. Now, these are the names of potential witnesses. We'll have to wait until testimony begins to see who is actually called. I'm Brian Buckmire for the Law and Crime Network.
Thank you, Brian. Lara, let's go through this a little bit. I mean, the defendant has a right to a fair trial, and people have a right to protest, that's for sure. And these two things are coming into conflict with one another. What do you think the judge should be doing or is doing correctly with regard to making sure they're balancing those rights between the right to protest, but also to ensure that a defendant, any defendant, police officer, defendant or not, gets a fair trial?
Well, I mean, as far as the judge is concerned, obviously he has to keep control of the courtroom and follow the law to ensure that every single right, the right to counsel, the right to a fair trial is protected within the bounds of the law. And I mean, up until now, I haven't noticed anything that stands out. I think he's doing what he's supposed to. The protesters are going to protest. You can't stop them from protesting. It's their right to do that. Now, we don't have any counter protesters. Maybe that would have brought some balance to it, but you can't make people do that. So it is what it is. It's the unfortunate part that's part and parcel of every single high-profile case. All this attention, whether it be media attention by the nation, and a lot of attention, and sometimes negative publicity from protesters. A lot of interest in the case. It makes it really tough to get a fair trial. And the one place that we would have to really pay attention is jury selection to make sure that the jury is in no way influenced by any of this. And that's the reason they've got this really, really long, from what I've seen, a long jury questionnaire. And that's to weed out jurors who've already made up their minds. And that is one place that all the parties, including the judge, will have to play a very important role to pick an impartial jury. I think that's where this case is going to be won or lost.
Yeah, jury selection obviously is the most important thing because they're the ones making the ultimate decision, excuse me, and making sure you don't have partisans that are already made their mind up, like you said, Lara, and they're either for the cop or they're for, the George Floyd side of the matter, is going to be a very, very challenging task. Well, we had our field people out there yesterday trying to tool around and ask questions of people and get a feel and a sentiment. Let's take a listen.
I'm hoping the best. I hope we come to the right decision, get some justice, and maybe we won't have to revert to what happened, the first time with the violence and looting and everything like that. So
I'm here because I'm angry, and I think so many people are angry. But I also, everyone coming together is with love, and I feel all different emotions.
Yeah, Lara, this is exactly to the point. I mean, this is not the first, nor will it be the last case. In fact, we covered one just last year where a juror wants to be on that jury and they are blinded to the scenario. The court will always try to say, well, even though you know about the case, will you just listen to the facts and evidence produced in the court and be fair and impartial? And it's very easy for a juror to say yes, but nevertheless, they're coming in with those biases. As a defense attorney, what are you looking for in a juror exactly? What kind of background would you look at to make sure that they're fair and impartial?
Well, I mean, if we're being very specific about this case, the defense is going to want people who are pro-law enforcement, people who, and also putting that aside, first and foremost, you're looking for a juror who can put aside all of their beliefs, their experiences, things that they've heard outside of the courtroom, things that they've seen or read in the media, and make up their minds and decide the case based on the evidence that they hear and see in the courtroom. That's number one. So you have to find someone who's willing to do that. Now, are people going to lie about it? My goodness, of course they are. We had the same problem in the Scott Peterson case. A lot of people want to get on these high-profile cases. I don't know. Maybe eventually they want to write a book, or it's just great to be on that jury to say, "Hey, I'm the one that convicted this defendant," or "I'm the one that got him acquitted." Whatever it may be, whatever their agenda is, a lot of people get on these juries with agendas. And my goodness, sometimes it's almost impossible to weed these people out, people that I call self-jurors. people who will say anything, and they know exactly what to say to get on that jury. We want fair jurors. I mean, the defense in this case is going to want. Go ahead.
Yeah, Lara, here's the thing that I look at. If I were prosecuting, I've prosecuted a lot of homicide cases. There is this Black Lives Matter versus those who are not in league with that, in an area where there's a smaller minority population in the jury pool as opposed to others. And that the prosecutor has to convince 12 people of this case beyond a reasonable doubt. All it takes the defense to do in that jury selection is find that one or two or three or as many as they can that know they support the police and know they're kind of against this defund the police and Black Lives Matter. And that could make the difference. I think prosecutors are more fearful here in jury selection than the defense. Is that a fair comment?
It's a fair comment. If you've got a majority, you've got the minority is the Black community, and the majority of the jury pool is going to be white, conservative individuals who are going to be pro-law enforcement, then that is problematic for the prosecution, because the prosecution wants BLM people. They want the really progressive. They want people who are liberal, the ones who have been protesting, have been on the streets screaming, yelling for Black Lives Matter and against law enforcement and against police brutality. So yeah, it could be a problem for them, but you never know. You never know. At this point, the way I see it is, it could be very difficult also for the defense. I mean, this is a case that's been covered by the media, and it's gotten the attention of the entire nation. And there's a lot of hatred towards these officers. And it's going to be tough to find sometimes jurors who are willing to say that they acquitted someone like Chauvin. I mean, this individual, this juror is going to be able to, and I'm sure the defense is going to address it. Are they going to be comfortable being known as the juror who acquitted this officer? And so look, you don't even have counter protesters because most people don't want to be out there saying that they're on his side. It doesn't seem to be something that people are comfortable. But you've got the BLM people there protesting because they're more comfortable protesting about this because they're so hated. There's been so much attention on this case.
Yeah. All right, great, Larry. Appreciate it. We're going to take a quick break here on the Law and Crime Network, but we'll be back with more on the other end. Stay with us. All right, welcome back. We are at the trial of Derek Chauvin for the killing of George Floyd. A little delay in jury selection as a legal issue populates, but there is also not just this state court prosecution, but a federal court prosecution. Let's listen to our very own Angenette Levy with regard to that.
There have been reports that a federal grand jury is investigating George Floyd's death and that the officers involved could face federal civil rights charges.
The video of George Floyd's final moments has been seen around the world, sparking outrage and calls for reform. Former U.S. Attorney Ben Glassman says it's a long-standing policy of the Department of Justice that state prosecutions move forward before a federal prosecution.
The idea is for the state or local authorities to go first. And if that investigation and prosecution is sufficient to vindicate federal interest, then there's no need for a federal prosecution.
Glassman cites two cases he handled during his time as U.S. Attorney for the Southern District of Ohio. The first, Corrections Officer Jason Mize pleaded guilty to using unreasonable force while acting under the color of law after throwing an inmate headfirst into a concrete wall in 2016. The state prosecutor declined to charge him. Mize is now awaiting sentencing. Then in 2018, Franklin Township Police Officer Robert Wells kicked a handcuffed man in the head and pleaded guilty to a federal charge and went to prison. In that case, the feds and the local prosecutor worked together. The investigations can be lengthy.
You need to have the federal agency go out and more often than not re-interview every witness with an eye towards the elements of that federal charge. And then you have to think about, are there other witnesses that you could possibly investigate and talk to that are related?
In the Wells case, Glassman says that officer lied about the use of force. Federal civil rights cases aren't often brought.
The willful standard makes it very difficult to prove these cases. It's a higher standard than just knowing. It's essentially saying that the the defendant violated the Constitution on purpose. Like, you knew what reasonable force was, and even though you knew that, you on purpose used excessive force.
But Glassman says those cases can be successfully prosecuted.
These are cases that it's incredibly important to bring if you are pro-law enforcement, because officers who commit these types of offenses tarnish the badge.
Ben Glassman tells me another reason that these investigations can take so long is because experts are often consulted, and the agents really have to look at the training the officers received to determine whether or not the force used was excessive. For the Law and Crime Network, I'm Angenette Levy.
Thank you, Angenette. Okay, we have another great guest, especially for this case. Alan Tuerkheimer, the owner of Trial Methods, Inc., that facilitates focus groups, moderates deliberation, and tailors jury research methodologies to fit whatever that trial team's objectives are, including mock trials to gauge the sentiment of the jurors and their reaction to what they're hearing as far as the evidence. He's a legal consultant from discovery to closing. He provides support services for attorneys. Welcome to the show, Alan.
Good to be here.
Okay, Alan, we got to ask you this. I mean, I'm always a big believer. Jury selection is important. It's been delayed for a day. It is one of the most critical parts of a trial to me, especially in a case like this, where many people have formed opinions and could potentially, in the jury questionnaire, as well as during the voir dire, give answers to get themselves on the jury for many different reasons. How do you, as a consultant, advise in a case of this magnitude with the public identity to this case and the public pressure and the protests? How do you advise your clients, let's say a defense client, on how to pick a jury, and what kind of jurors does the defense want?
Right. I mean, as you were talking about earlier, you want to make sure you don't have anybody who seems too eager to get on, but it's really tricky because these stealth jurors tend to know what to say to get on. They tend to moderate or temper their answers. They know to say they should be fair and impartial. So you have to take a holistic approach and look at the questionnaire items and listen to their responses in voir dire and make a full assessment in terms of, all right, does this person want to get on the jury? And if so, why? So that's the first part of what your question is. And from the defense perspective, in a case like this, you really want to have people who can get past the emotional aspect of the video, who are thinkers from a logic standpoint, who connect dots, who maybe are a little more methodical in the way they think, so that they don't just see that horrible video and make up their mind. They're going to want to, the defense is going to want to have people beside people who are a little more pro-law enforcement, people who have police officers as neighbors, who think that they are unfairly maligned, that it's a tough job, and that they're not going to be 100% perfect 100% of the time. But they're also just going to want to have people that will sit back, wait, listen to the evidence, maybe take a real look at the causation aspect of why he died, since that's an important, crucial element of the charges. And then someone who will have courage in the deliberations and not be fearful of what it's going to look like when they get back in their community.
Well, speaking of the community, our field crew is out there for the Law and Crime Network, getting all sorts of statements from people in the community. Let's take a listen to a little bit more.
It is a concern for all, and it's concern for people to really see what's going on here. People want a good outcome, and we know that everybody, whatever happens, not everybody's going to be satisfied, but what we want is to be able to be unified in the end, and we want people to feel peace and security and love in the end, and have our cities still be our cities.
Yeah, Lara, how much are you worried as a defense attorney about this community response that's out there in terms of its ability to infect the jury? And what kind of arguments, when you're up before the jury, either in opening or closings, are you going to try to hammer to get them to see this as do the right thing? And my last question, answer either one in any order if you wish. When you have the facts, you pound the facts. When you have the law, you pound the law. If you don't have anything, you pound both. But there are some nuances in this law that's tricky. And the facts of that video with him on George Floyd's neck is just not a pretty picture. So are you going to really attack the law as a defense attorney and try to confuse them? Because the law is somewhat confusing.
Starting with the first question, of course, as a defense attorney, I'm going to be worried about all this attention. You've got protesters, the potential jury, and eventually the jury that's going to be selected is going to be definitely impacted by these protesters. Imagine walking into a courtroom, having all these protesters right outside the door or close enough where you could hear them screaming, protesting. Just imagine the tension, the pressure on this jury to convict, and knowing that whatever their decision may be, these people, someone's going to be judging them. You did it right or you got it wrong. So it's a lot of pressure on anyone. I mean, these are going to be 12 jurors that don't even know one another. So the jurors don't have family members or people who are supporting them next to them saying, oh, you did the right thing. They have to talk to strangers, be with strangers for weeks on, and eventually come to a decision. And one of the things that you could do during voir dire is remind the jurors. I mean, they've got a job. They've got, and someone's life, someone has passed. It's a tragedy, but someone else, they have to decide if this person did the right thing or did the wrong thing, guilty or not guilty. And they need to put emotions aside. They need to put the outside pressure aside. They are there to decide the case on the facts, not on emotions, not on visceral gut feelings, not on what the media says, not on what the protesters are saying and screaming about, but not even what their family's saying, not what their neighbors will say and what they'll think of them when they are done with this case, but what is right. They need to be able to go back home when this is over and not regret their decision. It has to be a decision made on the facts and only the facts that are presented to them, the evidence presented to them in the courtroom, period.
Absolutely. That's the standard. But with social media and the kind of attention a case like this gets on one side or the other, that becomes much harder for the judge to be able to accomplish in the jury selection. We shall see, because that hopefully will be starting tomorrow. We're going to take a quick break here on the Law and Crime Network, but we'll have more on the other end. Stay with us, please. Jury selection may be halted, but we have breaking news. A march going on right now as we speak outside the courthouse. Let's go to it.
Away to come here to Minnesota to fight for her son that they stole from her. And she drives here faithfully. She's a warrior for not just her son, Cordell, for all of our families. When I was afraid to come forward with my story, she seen me on Facebook telling my story, and she reached out to me. And she took my hand and she said, come on. And I can never thank her enough, because she's been the inspiration and the push when you see me. This is why, because it was a mother that
Okay, folks, there you go. Before they got there to where that speech was being made, they were chanting as they were walking very loud. They are definitely making sure that their voices are heard. We may get to a little bit of that a little bit later on, but even though the court is not doing jury selection today, that is not stopping the community, obviously, for advocating for George Floyd. Now, again, our crew is on the ground there, and we have an opportunity to have Angenette Levy, who interviewed Mark Geragos, the famed attorney. Let's take a listen to that.
We've seen police officers put on trial over the years. Some have been convicted while others have not. Defense attorney Mark Geragos says some jurors simply have a hard time wrapping their heads around the idea of sending a cop to prison.
What I witnessed at the scene was 100% LAPD policy.
1991 in Los Angeles, 4 LA police officers beat Rodney King during a traffic stop. Those officers were acquitted in state court. Does that case foreshadow what could happen in the George Floyd case? Defense attorney Mark Geragos, who gained notoriety representing Scott Peterson in the death of his wife Lacey, believes so.
We've seen this movie before. The officers in Rodney King were acquitted because basically the case was moved to a jurisdiction or change of venue that was helpful to them.
2 of the 4 officers in the King case were later convicted in federal court of violating King's civil rights.
Here, you've got the same thing, at least arguably, starting to be set up. If you read what's been reported.
Several media outlets have reported a federal grand jury is investigating Floyd's death as a backstop. Even with Floyd's death captured on videotape, Geragos believes not guilty verdicts are possible.
Chauvin has got a tough case. I think it's going to be a very difficult prosecution to make the case against the other 3 officers, and especially 2 of the 3 who were rookies.
There have been other cases where the evidence appeared overwhelming only to end in an acquittal. In Cincinnati, campus police officer Ray Tenzing's 2 trials for the shooting death of Sam DuBose in 2015 ended in hung juries, and a judge later granted a motion for acquittal. A federal investigation is underway in that case, but a jury also found Chicago police officer Jason Van Dyke guilty of second-degree murder in the 2014 shooting death of Laquan McDonald. Van Dyke is serving prison time for that crime. Everything will be under a microscope in the Chauvin case, including the officer's training and restraint techniques, which medical experts say caused Floyd's death. Minneapolis police had been trained in a technique that includes placing a knee on a person's neck.
It wasn't just the knee of Derek Chauvin on George Floyd's neck for 8 minutes and 46 seconds that killed him. It was the knee of the entire Minneapolis Police Department that killed George Floyd, because they have a pattern and practice of deliberate indifference to arrestees, especially young Black men.
Meanwhile, Mark Geragos believes Derek Chauvin will take the stand to try to explain his actions.
They're going to be testifying, because cops almost inevitably in these cases testify because they're used to getting up on the stand. They're used to giving their point of view. Alan Dershowitz calls it test the lie, but I won't go that far. But I will tell you that the cops will get up there. They will invoke officer safety.
Derek Chauvin's lawyers are expected to argue at trial that fentanyl in George Floyd's system actually killed him, and not the pressure being placed on his body while he was being restrained. For the Law and Crime Network, I'm Angenette Levy.
Thanks, Angenette. Always a great job. Alan, I want to go to that last point that Mr. Geragos said. Now, Ben Crump, the attorney, was giving the civil standard for a 1983 civil rights deliberate indifference charge, but that's not what the criminal case is about. I think, at least standing right now, and of course, you never make this decision as a defense attorney until all the evidence is in, but right now, I'm suspecting that I do not want Derek Chauvin on that witness stand, because the prosecutor could have a lot of cross-examination. And the other point I want to bring out is, how do you, as a jury consultant and as a trial consultant, get around that idea that he's got his knee on his neck while his hands are in his pocket?
It's hard. It's very difficult to explain that. I think they're going to have to really get into the mentality of somebody who was interacting when he was trying to place George Floyd to sort of control him, corral him. I think they're going to try to explain and get into some of the things that Floyd may have done or not done in terms of listening to the officer's directions. Now, will that get him far? We don't know, but there are some who believe that they won't get past the fact that if a police officer tells you to stop, hold still, and comply, some people just think that anything that you do after that, no matter what, no, they're not, you don't deserve to be killed, of course, but they'll say that, look, it's your fault, and they'll kind of put the blame on the person for not listening to the police officer's requests and demands.
Right, but Lara, yeah, and I agree with you, but Lara, this case is really different than a lot of those other cases, because there's a significant period of time where there's no resistance at all. I got a short period of time. I think that's what sets it apart. Give 15 seconds or less. What do you think?
Of course, it's problematic, because he can justify, okay, he did it for a minute, 2 minutes. At that point, he's not responding anymore. He's not responsive. Why does he still have his knee on his neck? So So obviously the defense is going to have to explain that. Was that really within the policy? Just stay there up until the complete arrest was done?
Good.
It's a problem. It's a challenge.
Okay, guys, thank you so much for this commentary. Stick with us because we're going to be carrying this case gavel to gavel. I'm Bob Bianchi. We'll be right back. All right, welcome back to the Law and Crime Network, Law and Crime Report. My name is Bob Bianchi. We're covering this fantastic trial of State versus Derek Chauvin, the former police officer accused of killing and murdering George Floyd. Jury selection delayed for at least one day, and this legal issue that's developing with regard to the judge having previously thrown out a third-degree murder charge that prosecutors desperately want into the case, and they got a good result last week from the appellate courts. It said, no, this is reversed, but go back to the trial court who can still make further findings. So this issue is not yet resolved, and the defense vowing to go to the Supreme Court to resolve this issue. So this third degree, this hearing was really, really pivotal and can make a huge difference in the outcome of the case. Let's go to part of that hearing and take a listen to the special prosecutor in the case, Neil Katyal.
The state should win this appeal for two independent reasons. First, stare decisis. There is no more foundational principle to our law than that decisions of this court must be followed by lower courts. Here, that didn't happen. Instead, the trial judge expressly said that he agreed with the Noor dissent and blocked the state from charging third-degree murder. What third-degree murder is an interesting question, but it's besides the point here. You've decided the question in one direction, the trial judge decided it in another. Without action from this court, a landmark criminal case, one of the most important in our nation's history, will take place with a major part of the case, third-degree murder, missing, nowhere in it whatsoever. That can't possibly be the law. A trial judge can't have a unilateral veto to block this court's decisions. In making matters worse, that error can never be fixed due to jeopardy. The harm here is asymmetric. If you rule for us and later the Supreme Court reverses Noor, Mr. Chauvin will have ample opportunity to seek reversal of his conviction on appeal. But if you rule against us, we'll never be able to charge third-degree murder, ever. A trial judge shouldn't be able to do that. And second, the trial judge challenged the Noor decision, saying he sided with the dissent. And that's just wrong on the merits. The third-degree murder statute doesn't require proof that the Defendant's Act was directed at more than one person. Noor, in effect, was right. That's why the answer to the sole question, Judge Larkin, that you presented is in the state's favor.
Lara, let's break down what he's saying. Again, it can sound kind of wonky, but it's really, really important. When the appellate court ruled and reversed the trial court in the Chauvin case, in this case, they did it really on procedural grounds because, as Neil Katyal says, the trial judge said, I don't agree with this Noor decision. That's a previous case. I agree with what the dissent said, and essentially said because the Supreme Court has not yet ruled on it, he was going to throw that third-degree charge out. So the argument by prosecutors is, no, that is a precedential decision. It's got precedent because it was from the appellate court. And that's what the appellate court pretty much rebuked the trial court judge in that decision and said, no, you have to follow that precedent. But again, I want to get into why this is so important, because on the third degree charge, while there's no intent that's required, it's an act that is eminently dangerous to others, plural. It doesn't say another, it says others. And so I've looked up a number of cases here from Minnesota, and a number of them seem to have always indicated that it would have to be with respect to the actions were focused not on a specific person, but others. And apparently this Noor decision changed that in the appellate courts. And yet again, I say it has not yet been decided in the Supreme Court. I mean, this is a really nuanced but important issue.
A very important issue, because if we're talking, if the trial court is correct and the Supreme Court ends up affirming, basically, actually, the Supreme Court agrees with the trial court and says, no, this has to be directed to a number of people, multiple individuals, not just one individual, then you know what? If the third degree murder is allowed in, then it's problematic to the defense. I heard the special prosecutor saying, we've only got this one shot to get this third degree in. Mr. Chauvin can later appeal it. So if we're incorrect, if the appellate court is not correct, then maybe later he's got remedies. But wait a minute, maybe he forgot something. The defendant is entitled to a fair trial. It's not the prosecution that's on trial; it's the defendant that's on trial. And the judge, it sounds like the trial judge here is basically following what most of the courts have followed. I mean, it looks like it's been interpreted previously on many occasions as applying to plural complaining witnesses or victims or deceased or whatever, a group, not just one individual. And like you said, Bob, the appellate department, the appellate court suddenly changed that. Well, it's very likely that the Supreme Court of Minnesota may not agree with the appellate department. I understand it's got some precedence, but at the same time, there's a lot at stake here, and it would make sense to see and not take a chance on the fairness of the trial involved here.
Yeah, I agree. And Alan, as a prosecutor, I just don't want to be in this world where our trial, where I've got a body of law that says something different that the North appellate court is saying. And it is true, it is precedential, but I don't want there to be a conviction and then have it reversed and try the case again. I want that legal issue to be decided. And so that the folks know here, the difference is with the second degree murder, it requires an intentional act to commit an underlying offense. In this case, a third degree assault. And that reads, the attempt to inflict bodily harm upon a victim or act done with intent to cause Floyd to fear imminent bodily harm or death. The defendant inflicted actual substantial bodily harm on Floyd. So, I mean, there's the difference there. One is like a higher burden for the prosecution on the second degree, but on the third degree, I mean, if the court allows it, who can say? I'm just asking. I mean, I'll come up with a defense if I have to, but as a prosecutor, I love that charge because I just have to show conduct that was imminently dangerous to others and evidencing a depraved mind without the regard to human life. And you take a look at the picture that's on the TV right now for close to 8 minutes, if not longer. How are you going to argue that with a man who's saying, I can't breathe, I want my mother, and then goes limp and the knee stays there?
Right. It's a really difficult hurdle to overcome. And so you can understand why there's this battle going on. And in deliberations, there's a lot of give and take. So you might have some jurors on one end, then the other. Look, most deliberations start off without jurors going right into the law and answering these questions. They piece together information. They come up with a comprehensive story. They look at the narratives, and then they, in their minds, tend to, for lack of a better term, back into a verdict. They'll decide what they want to have happen. They'll think about the outcome. So if they have this other option with the third degree, then that just gives not only some jurors a little more leverage to argue and compromise, but also it widens the scope and then gives them another shot at finding against the defendant.
Yeah, Alan, I got to ask you this. I mean, from watching this case and when we've done legal commentary on it, it is clear that there's a lot of political thinking that goes into both sides of the equation. There are those on the Black Lives Matter and defund the police side that, if you listen to them, they just want a fair trial that results in a conviction. And then on the other side of that equation, they feel that the police are being preyed upon and they're just doing their job. And when bad things happen, everyone jumps down their throat. Is it possible with the polarization, the political polarization of legal matters, which I've seen in the last 5 years developing well before George Floyd, that you can really get jurors that are going to go in there without that unbreakable perspective?
I think you can. The way they're doing it, they're not having that many come in, and it's going to be a process over 2 or 3 weeks. So, and there's so much in the questionnaire. I think they could probably just look at the questionnaire and look at some of the responses and think, okay, we have some that are really extreme on one end, the pro BLM side, and then the pro police side. And some of them, I think, could just get tossed. They wouldn't even have to waste their time bringing some of the jurors in. But then at that point, I think once you get down to it, of course, people know about the case. Of course, they've seen the video at that point. Then they have to really dig in deep and try to determine whether or not somebody, yes, you can still pay attention to the news, but not have a vested interest. And so that's what they're going to really have to do. It's going to be a challenge. I think they can do it, given that they have all this time to pick a jury, but it's certainly going to be a real challenge.
Right. Excellent. Well, let's listen to the judge today, who had a flurry of things happening over the weekend with respect to what's going on in this case. This is from today.
I may be speaking a bit ahead of my teammates, but we would, move expeditiously, of course, on responding to the PFR. I suspect the Supreme Court would as well, but I certainly can't speak for them. But we would try to be expeditious in the process too, of course.
All right. Well, the court's view is that I don't have jurisdiction to consider in any way reinstating the murder in the third degree because judgment has not been entered by the Court of Appeals, and so jurisdiction has not been passed back to the district court on that issue. However, I do find that the other matters, including jury selection, are not matters related to the appeal and that we should go forward on them. And so that's the court's order. I expect that we will do motions in limine. I find that those are also not related to the appeal, except if there's anything about murder in the third degree, but I don't think there is from my review of the motions. And we summoned the jurors for 8:30. I don't know if they've all reported by now, but they also have to watch the standard jury orientation video. The idea was that we would start jury selection at 9 or 9:15. This is what I suggest. We take a recess at this point, because clearly you are within your rights at this point, since you think I may be acting without jurisdiction, to seek a writ of prohibition. And so I'll give you some time to talk to your team and see if you want to get that started.
That we are going to seek further direction from the appellate courts about whether the court can proceed, particularly with jury selection, while that appeal is pending. And so my understanding, Your Honor, is the court will give us an opportunity to get that perfected and get that process started with the Court of Appeals this morning. And so we would ask the court for a break to go do that, take care of that, and we'll get that filed with the Court of Appeals.
And Mr. Nelson, anything to add?
No, Your Honor.
All right. I did indicate it was my intent that we go forward with motions in limine and jury selection, unless someone tells me not to. I think you have the right to seek, to file a motion with the Court of Appeals, but also I think to call the Court of Appeals for a telephonic writ essentially to stop us from going forward while your motion is pending, or if that's what they want to do. And so I would, just looking at the clock, we have jurors, but I think realistically we're not going to get to any jury selection. We won't have an answer until at least tomorrow. So unless any of the parties object, I'm going to kick our jurors loose and start everything tomorrow with jury selection. If the parties can agree that I have jurisdiction, or the Court of Appeals agrees that I have jurisdiction, then we can spend the morning, in fact the whole day, on motions in limine. And we won't know that until we hear what the Court of Appeals says, because if they issue essentially a telephonic writ telling me to stay everything and tells me how long, I hope, then we can proceed accordingly. Anything to add to the record, though? Otherwise, we're going to stand in recess. Let's come back at 10 o'clock and see where we're at with the Court of Appeals.
All right, Lara, break this down for us with this jurisdiction issue. He was talking to the judge about the fact that while appeals are pending, they certainly can do in limine motions. Those are preliminary motions, usually on the admission of evidence, evidentiary stuff, as well as doing jury selection. And the appellate court, when it remanded it back to the trial court, said this did not prevent the trial court from making decisions with regard to this third degree charge. What I think the judge is trying to say, or what the argument here is, that usually when it's on appeal, all the proceedings with the lower courts are stayed. But what's going on in your mind here jurisdictionally?
Clearly, everybody is having an issue with this. You've got the prosecution saying you're going to seek some guidance from the Court of Appeal because the judge feels that he can proceed. He doesn't think that whether the third degree comes in or not has any impact on jury selection or motions in limine. He's saying we could do these things and get them out of the way. Why not do those? Why not proceed? Prosecution is not comfortable with that. Prosecution doesn't want to do it. They want to seek some guidance from the Court of Appeal. It's almost like even the judge was literally directing a lot of these comments directly to the Court of Appeal, even though he was talking to the prosecutor, basically saying, give us guidance, because clearly there's a disagreement here. I think I've got jurisdiction to move forward and deal with the rest of the issues, jury selection, whatever issues there are. But if you think otherwise, Court of Appeal, let me know. Send in some direction, clear directions, including how much time, how long this case should be stayed. So clearly everybody's looking for answers and for guidance from the Court of Appeal.
Yep, very interesting to see if the Court of Appeals will respond to that. Thank you very much for that answer. You guys are great. We're going to take a quick break here on the Law and Crime Network, but we'll be back with more. Stay with us. Community support for George Floyd, as you know, has been amazing for many, many months, and you wouldn't expect it to be any less, if not amped up more, during the course of this trial. Let's listen to March 5th, Michelle Gross, who is from Communities United Against Police Brutality, and what she had to say.
Good afternoon, ladies and gentlemen. My name is Michelle Gross, and I am one of the founders and currently the president of the organization Communities United Against Police Brutality. We celebrated our 20th anniversary in December. Before you, what you see is a scroll of names of people who have been killed by law enforcement in the state of Minnesota. 5 of the names on this scroll belong to Derek Chauvin.
Listen!
This man is not a one-time killer. He is a serial killer.
Listen!
And it's important that we recognize that as he was acting as a serial killer, the city of Minneapolis failed time and again to hold him accountable. And because they failed to hold him accountable, because they failed to have policies in place that would end his reign of terror, because of these things, they created the conditions that allowed George Floyd to be killed. That is a fact. Now what we're going to see on Monday is a trial of Derek Chauvin, and he will be only the 4th officer in the history of the state of Minnesota to be prosecuted for the killing of a member of the community. Only the 4th. The first one was Geronimo Yanez, who killed Philando Castile. He was acquitted. The second was an officer named Brian Crook, who killed a man named Benjamin Evans. He was acquitted. The third was, as we know, Muhammad Noor, who killed Justine Damon. And he was convicted, the only black officer to kill a white person, and then he was convicted. And now we have Derek Chauvin killing a black man. Let us see what these courts do with that. Let us see. And what I will tell you is we had better see some justice.
Listen!
I fear that if this man walks with a slap on the wrist or he walks acquitted, it will unleash a reign of terror by the Minneapolis police on our community that we have never seen before. I am deeply fearful of that. And we must hold these officers accountable. We have no systems in place that do that in this state or in this city. We're the city where an international movement jumped off larger than any prior movement in the world. We are the center of where that happened. And yet, we cannot get our bills across the finish line. We cannot get our city to put into place policies to address police violence. Instead, they ring their buildings in chain link fences, barbed wire, and razor wire because they fear the community more than they fear police violence. And that is shameful. We are here to say that we stand with these families. We are here to say that we will be out protesting. We own this community. It is ours to protest as we choose. We will not be following their First Amendment busting rules. By the way, we sent a letter this morning signed by all of the organizations to Hennepin County Government Center, making it clear that if they do not remove these unconstitutional rules, where they're talking about you're not allowed to have a sign on the government plaza, you're not allowed to use slogans that they don't approve in advance, all of this kind of nonsense. If they do not withdraw those rules immediately, we will see them in court. We will use our First Amendment rights to stand with these families and to demand justice for all stolen lives. Thank you.
All right, let's go to Angenette Levy again, who is live out there in Minneapolis, like many of the crew that we have here, the awesome crew at the Law and Crime Network. Angenette, tell us a little bit about what that was about, and is this kind of community involvement going on in multiple places with multiple groups?
Yeah, it really is. There are several groups that have come together to organize these rallies and these protests. I actually spoke with Michelle Gross just a short time ago in the last couple of hours, and she is one of the people who's really spearheading these rallies and these protests. And she told me she's actually really upset about all of the fencing and things like that around here, around the courthouse, because she believes that that's sending some type of signal to the community about a potential outcome of the verdict. She said to me, I believe, people feel like they're going to just let him off, and so they're protecting the courthouse from the people and the protesters, and she's really concerned about that. She doesn't feel that it's necessary, so she is pretty upset. We also want to show you video of a protest that she helped organize yesterday. That was the silent march for George Floyd. There was a white casket that was covered with roses, and they were carrying this throughout the streets of downtown Minneapolis. There was music playing. There were signs. There were probably 200, 300, maybe even 400 people there. Quite a few people were there for that event, and then they circled back for a prayer here at the courthouse. But then there was also an event here yesterday with clergy, other religious leaders, for just anyone in the community who wanted to come out and offer a prayer for the community, because there is a lot of tension here, a lot of uncertainty. People don't really know what's going to happen with this trial.
Angenette, it's been my experience as the prosecutor that whenever you have one of these kinds of cases, we talked about this a little bit before, the police feel the need that they need to have their voice heard, their presence there, and apparently that's not happening. One, do you expect it's going to happen? And two, with that crew of people that are out there, have you gotten anyone that's supportive of the police at all, even though they may not be in a massive group? They're quietly in support of the idea that this officer is being wrongfully charged?
Yeah, we haven't seen that just yet, Bob. And I recall when this happened last year, and you may recall this too, I had seen even police officers, police chiefs in other cities speak out against what they saw on that video. But it's important to point out, Derek Chauvin's position in this is that he is saying his use of force was reasonable, that he was trained to use that maneuver, and he's contending that George Floyd actually died of a heroin overdose coupled with some heart issues. So there's another side to this story. The other side hasn't come out as forcefully and as loudly, but there are people, I can tell you online from things I've seen on my Facebook page and in other places, there are people who actually support Derek Chauvin and believe that he is not guilty of these charges. Obviously, it's going to be up to the jury to make that decision.
Yeah, Angenette, that very sentiment, and I always say that separates these cases where people say the cops always get off versus ordinary people. And a lot of times that's because the police are allowed to use what's called the police continuum of force, where they don't have to fight a fair fight. And there are certain ways that they are trained. How much is this training issue, i.e. that they're allowed to put a knee on the neck as partial restraint, going to come into this defense as you know it?
I would think that based on the documents we've seen the defense file thus far, I would think this is going to be a huge part of it. I actually saw some documents. We have some PowerPoint slides from one of those motions in which they submitted that training and show a picture of somebody on the ground with a knee on the head or the neck area, and then two other officers holding the legs. So I think the training will come into that, along with what was in Derek Chauvin's mind at that point in time, and a lot of people believe he will take the stand to tell the jurors that.
Well, I'll tell you, Angenette, the hands in the pocket was the thing that always got me in terms of having to use that level of force in order to restrain somebody who's not even moving. Angenette Levy from the Law and Crime Network, you will be out there with the rest of the crew, always doing a great job. Thank you so much for being on the show.
All right, thank you.
Okay, you got it. We're going to take a quick break here at the Law and Crime Network. We'll be right back. All right, welcome back. So, the judges delayed jury selection for at least a day right now. We should be starting up tomorrow with that. But it really gives us a great opportunity to put our arms around what this case is all about, both from a legal point of view as well as a community point of view. So last Friday, there was a press conference that was done with regard to police brutality from the mother of Philando Castile, who was shot by a police officer during a traffic stop. Let's take a look.
Most of you know me, I'm Philando Castillo's mother, Valerie Castillo. We have gathered here today as a visual statement. We're making a statement today because we're all standing here in unity. What happened to Philando should never have happened to anyone. And my question is, where do we go from here when your honesty and integrity means nothing? My son told the truth and he was honest about that weapon. And in turn, he was murdered. He was shot 5 times. That man was so close to my son's body that the blowback went back on him and there was a bullet casing inside the car. Who is going to go into a shootout with a woman and a child in the car? I mean, come on now. This mess is crazy. And the guy was acquitted, and you had everything you needed to get a prosecution. He should have been convicted with the amount of evidence that was against him. He should have been convicted, but he wasn't. But we stand here today in unity and in force. We're here in force. We're making a statement today. We're making a statement today because we're not going to tolerate and sit back and not say nothing about the murder of our children. Because it could be any one of you. Any one of you could be murdered by the police and nothing will be done because they were in fear for their life. That's in fear for my life is too vague. They need to have that more ironclad where he has to know that he was actually in fear for his life. You can't keep saying that. Freeman made a precedent. He convicted someone. But we're going to have to be brutally honest with what's going on in this country. The only person that's in jail is the black guy. Listen! Out of 400 and some people that have been murdered by the police here in the state of Minnesota have been not charged, acquitted, but the only person that's incarcerated is the black guy. He committed the ultimate sin. He killed a white woman. We're gonna stop this foolishness today. We're gonna stop the foolishness. We're gonna tell the truth and shame the devil. But we are here today to stand in unity as a visual statement to the state of Minnesota that we're not gonna shut up. We're not going to sit down. We're going to stand in unity and we're going to bring it to you. With this bill right here. Call in, email, whatever department is in to make sure that this bill is passed because we want this to stop. Our kids deserve a chance to live.
All right, Alan, this is right up your wheelbase here. You see what's going on from these clips we're playing in the community, the demonstrations that are happening out in front of the courthouse. You've seen the video, you know all about this case. You are a person who actually facilitates focus groups and mock juror reactions to trial strategy. What are you doing for a case like this if you were retained for the defense?
Sure. Well, you certainly want to get some of the attitudinal beliefs and see what is the pulse of the community. Now, it's pretty clear. You see a lot of organizations and people that are talking about what's going on. You want to see what the jurors come in with. You want to get their baseline because in terms of jury selection and any kind of jury research you do, you want to know what the baseline is. So you want to gauge what people are thinking, what they're talking about. And then you want to see, okay, how does that relate to the specific facts of this case? Now, obviously, there's so much going on, and these jurors can't go to the courthouse and not realize that around them, the world is watching, there are all these protests going on. And so that has to be a consideration. The key, if I was retained, I would say, okay, this is what we know, and this is what we're going to do in terms of implementing the case story and some of the themes we know. But the key is to, once the jurors get in there, and this is what will happen, they'll be able to focus on the evidence, they'll be able to focus on the witnesses, and some of that stuff will start to dissipate in their minds, but it's not going to entirely disappear. So it's a tough balance you have to make because it exists, but really when you're helping the defense with all these decisions they have to make about what strategy to take, does Chauvin take the stand, you really want to hunker down and focus on what the reaction is going to be and try to get all that other stuff set aside. It's hard to do.
Right. So when you talk about mock juror reactions in your consulting group, just tell our audience, what does this look like? Do you get a bunch of random people that represent the statistical population of that community as close to the demographic as you can? And then the lawyers kind of present the case, and then afterwards you kind of poll them, and then you kind of change it up and see if they would have come to a different conclusion if you said it differently or presented different evidence. Is that how that works?
Yes, you bring in people that represent what the jury looks like. You match the demographics. You say, okay, Hennepin County is 80% white, and then you want to get a range of age, occupations, and get them in there. And then, as you said, they would hear different facets of the case. You'd hear, all right, here's what the prosecutor has to say. Get some feedback. Here's what the defense has to say. Get some feedback. I think you'd do a service. If I was working for the defense, I would say, hey, here's a videotape. Some videotape of the officer, Chauvin. Let's hear his explanation, and let's get some focus group reaction to it. Hear what these people have to say, what they expect. Do they believe him? Do they like him? And then take the results and try to turn that into a litigation strategy, and try to also come up with a juror profile to see, okay, who is it that's going to get in there and either try to hang the jury, try to argue for an acquittal. This is if I'm hired by the defense, of course. And who's going to look at the evidence and give our client a fair shake. If I'm doing a mock trial and I hear people saying some of the stuff about protests, and they're talking about things that are certainly important, but that are outside the scope of evidence, I'd get very concerned. And that's the kind of juror I wouldn't want to have seated in this case. Somebody who comes in there, instead of looking at the evidence, the witnesses, and the testimony, talks about social justice and all these other things that are going on right now.
I think that is really fascinating about whether to put the defendant on the stand or not, because we've seen some cops that have gone on the stand in a couple of cases that we've covered gavel to gavel here in the Law and Crime Network, and it was disastrous, and I think they led to a conviction. But that viewpoint of the jurors listening to the defendant is really insightful. Anyway, we have even more of press conferences and statements that were taken on Friday from about police brutality. This one from the sister of Andre Madison, who was shot by a police officer in 1996. Let's take a listen.
My name is Carlotta Madison. My brother Andre Madison was shot by Minneapolis police 24 years ago in 1996. I at first wondered if it was still relevant since it happened 24 years ago. But the thing about it is that it's still happening after 24 years ago. They served a no-knock warrant. They shot a flash grenade into the place where he was. And then the police proceeded to start shooting at each other because it was a chaotic scene where they didn't know who was they came from the back and from the front. It was actually in the police scariest shootings videos at that time. And they were shooting at each other. My brother hit the floor and was still shot in his arm and in his neck. Luckily, he survived that, and he was able to tell his truth, his side of the story, where they put their foot on his neck and told him to die. So I'm here today in solidarity with all the families that have been going through this since 24 years ago, and I want justice to be served. Thank you. Thank you.
Alan, just curious, you kind of mentioned a little bit of this before in jury selection, when you're looking for jurors, prosecution wants one kind of juror, defense wants a different kind of juror. As a defense lawyer, if there's a case that's got some interpretation to it, as to either what the law is or what the facts are, what the training, it's going to be a lot of information this jury is going to get about all sorts of different things. Do you want to pick as a defense attorney somebody who is in a profession or in a job that is very exacting, like mathematicians or accountants or scientific people that want to work on objective data rather than subjective conclusions?
I think generally that's true. I think with this case, I think the overriding concerns are more about attitudes and experiences with the police and race. But I agree with that. The defense is going to want people who are going to look at the letter of the law, and they're used to applying things to the law. They read things, and they're not going to get caught up in some of the emotional stories, some of the emotional components of what the family members are bringing to the courtroom. And there's certainly variability within professions, but I do think that there is something to be said. And by the way, this is a very educated venue. I've worked here a lot, and I lived in Minneapolis for 3 years. There's going to be a lot of jurors who are very successful, very higher on the SES scale, that have done well in their careers. And I do think that that's something they're going to have to take a look at. And the defense is going to want people who are going to not just come in and have an emotional based reaction, not going to be unduly swayed by the video, but as you alluded to, they're going to read everything to a letter. They're going to look at the law, and they might feel like he did something wrong. This is the defense hope, that Chauvin did something drastically wrong, but the law is on his side. And that's what we see in some of these cases.
And that's why prosecutors want that third-degree murder. I am sure. That excellent commentary and great insights. We're going to take a quick break, but we'll be back with more. Welcome back. I'm your host, Bob Bianchi. So the jury is out for at least one more day until selection starts to begin. But I'm being told that at 1:30 local time, 2:30 Eastern Standard Time, they will be back in court on some motions. Before we get to that, however, we want to talk about Dr. Michael Baden, who found that there was no underlying conditions leading to Mr. Floyd's death. He is the famed forensic pathologist, medical examiner, and husband of our great host here at the Law and Crime Network, Linda Kenny Baden. Let's take a listen.
The autopsy shows that Mr. Floyd had no underlying medical problem that caused or contributed to his death. This is confirmed by information provided to Dr. Wilson and myself from the family. He was in good health. The compressive pressure of the neck and back are not seen at autopsy because the pressure has been released by the time the body comes to the medical examiner's office. It can only be seen, serious compressive pressure on the neck and back can only be seen while the pressure is being applied, or when, as in this instance, it is captured on video. And in this instance, we can see after a little bit less than 4 minutes that Mr. Floyd is motionless, lifeless, and when the EMS arrived and put him on the stretcher without any CPR at that time, during the ambulance trip, he did not respond to CPR and did not respond to cardiac shock. The cause of death, in my opinion, is asphyxia due to compression of the neck, which, as Mr. Crump indicated, can interfere with blood flow and oxygen going to the brain, and compression of the back, which interferes with breathing. When he said, "I can't breathe," unfortunately, many police are under the impression if you can talk, that means you're breathing. That is not true. I am talking and talking and talking and not breathing in front of you. So the concept that a person says, "I can't breathe," like Mr. Garner, like in this instance, means you should take it seriously.
For Dr. Baden, you previously conducted an independent autopsy of Eric Garner following his death. How does Mr. Floyd's examination compare to Mr. Garner's?
Thank you. Yes, I was asked by the family of Eric Garner to do a second examination, but what is different is the initial autopsy in the New York City Medical Examiner's Office concluded on day one that there was enough evidence to show that he died of asphyxia, because he couldn't breathe because of the compression of his neck and back. And that was immediately put on the death certificate, as opposed to this situation, which is the more common situation, where things are left pending while additional studies are done that will not reflect on the cause of death. It'll reflect on the circumstances of death, but whether he has drugs or alcohol in his body, for example, is not a cause of death. It would be a circumstance of a cause of death. But with Eric Garner, with a video that's still on the internet, a 2-minute video of Eric Garner on the internet, showing him saying, I can't breathe, many times, and that he becomes lifeless as Mr. Floyd and dead within 45 seconds. From the moment the 4 police officers touch him until they get away because they know he's lifeless was about 45 seconds. And so there are similarities, and that in that instance, there was a waiting time between the Justice Department and the New York City Police Department without any charges being brought, with no criminal charges being brought against the officer that did most of that compression. And it just goes to show that no matter how much video you have, there are many obstacles in the criminal justice system in this country, especially when it comes to black people who die while being restrained by white police, unfortunately. And I'm somebody, as mentioned, 50 years I worked with city and state police in New York. And I am very pro police work in general, but there are more than a few rotten apples that come up in the deaths that occur during police restraints, and that has to be further addressed, and hopefully this will help do that.
All right, welcome back, Lara. I want to go to you on this real quick. Dr. Baden, famed pathologist, a man of impeccable reputation. He's a brilliant guy. He said that, unfortunately, a lot of police officers and many members of the public have this training that if you can talk, you can breathe. And I can tell you that that is, in fact, training that police officers and some EMS people get. Don't do the Heimlich if the person can talk, because that means there's an exchange of air going back and forth. And then he talked about the idea that they don't know how much of that force is used that could cause the mechanism of injury. So let's go to these charges. The second-degree murder requires an intentional act, an intentional assault. Intentional is a state of mind. It means that was what, his intentional action was to inflict or attempt to inflict bodily injury. But if he is being trained that if a person can talk, then they're, as Dr. Baden indicated, that they are not in jeopardy of not breathing. And then going to third-degree murder, which is perpetrating an act that is eminently dangerous to others and evidencing a depraved mind without regard for human life. Is it possible, the defense argues, to Doc's point, that yes, he didn't know that. He was trained to do this, and he thought that if the person could talk, that they were okay. Of course, that doesn't explain a number of minutes when he wasn't talking. But I'm just going there. Is that going to be an argument?
I wouldn't be surprised. That's a natural argument, saying that he didn't think this man was going to die just because he's saying
I can't hear you,
breathe.
Lara. I'm not sure if you're muted or.
Can you hear me now?
Yeah, you go. Go ahead. Let's hear it from the beginning.
There you go. So basically what I'm saying is the defense, of course, is going to have to make that argument. What is that officer thinking? Is he intentionally assaulting someone here or not? This officer, of course, is going to say, you know what? He was saying, I can't breathe. I'm trained in the academy that if someone says, I can't breathe, as long as they can talk, that means they can breathe, and there's no harm. There's no issue. I can continue applying the pressure to the neck to subdue him. This is someone who was not cooperative. He was fighting us. Whatever the facts are, and they're going to come in later. And maybe the argument can be that, you know what, he was within his rights. He was following policy and procedure, and it's unfortunate that Mr. Floyd died. But it's not his fault. There's a causation issue and also an issue when it comes to the intent. assault him. That's why the second-degree murder is a little problematic for the prosecution. There's also all sorts of arguments that can come in here.
Alan, real quick, I got 15 seconds. What are your thoughts?
Yeah, no, I think that's true. I think they're going to have to argue what they're dealt, and they're going to have to try to get into his mindset. Maybe he'll say something like he's heard defendants or he's heard suspects over the years say they can't breathe, and they can. We'll have to wait and see, but I think that's just that's the pathway they're going to have to take.
We will. Okay, guys, thank you so much. The effervescent Michael Bryan is up next. Please don't go anywhere. We have more coverage coming up.